My name is Daniel Horowitz, and I am a lawyer in California. I am making this video as a warning. California fires have devastated this state for over a decade, and it is about to get much worse. California has passed laws that are guaranteed to create a fire catastrophe in the future that will dwarf our Los Angeles, Paradise, and other major wildfire humanitarian disasters. Our legislature has been captured and is now controlled by huge developer money that has created a build, and sell process that will allow unhinged and wild building development without police, fire, school, or child safety protections. All attempts by cities or suburbs to protect their residents and children will be crushed by million-dollar penalties in lawsuits filed by predatory law firms. The destruction has already started. Builders and politically motivated housing activists are hiring soulless, huge law firms to sue cities when they try to put public safety ahead of development. The lawsuits are forcing cities to face economic destruction unless they surrender and approve mega projects. These mega projects will create giant apartment buildings on crowded streets. Fire danger is soaring. Buildings are going up without adequate water, fire, police protection, and without any regard to schools or safe places for children to play. These laws are deliberately designed to destroy suburbs and to turn all areas near central cities, such as San Francisco, California, into urban jungles. Developers can build and sell condos without paying for fire protection, without caring about huge traffic jams, and without worrying about the destruction of the very towns where they are building. It is an unholy alliance. Huge for-profit law firms sue cities on behalf of large developers. They collect multi-million-dollar legal fees out the pockets the cities. The builders and large law firms use individuals as their plaintiffs, but these are not real people. Oh, they are alive and have heartbeats, but they are political operatives whose goal is to destroy the suburbs and small cities and transform them into a dystopian urban nightmare that fits their futuristic view of a just and equal society. They lend their names and faces, but the money comes from the developers and law firms. These laws are unconstitutional, but the cost of fighting this monster machine is so high that the cities keep capitulating. They can't afford to have a judge rule against them because they have to pay the developers legal fees. These laws deliberately destroy the ability of a city to protect its citizens. Los Angeles is going to be the victim of these laws. People can't afford to rebuild, and where people once had houses, you are now going to see housing projects and concrete jungles. Don't believe for a second that the state of California is going to stop these predators from scooping up the land and building. Money will prevail and profit will prevail. In 10 years, you will have 3 times the population density, but water, fire protection, and evacuation plans will be stuck in the same underfunded failure mode as we had in 2025. Here are just some of the many reasons these laws cannot survive a constitutional challenge. First, let's discuss the concepts of police power and zoning authority. Zoning laws are a manifestation of the police power granted to states and local governments. This power allows municipalities to regulate land use within their jurisdictions to promote the public welfare. The case to look at is Sacramentans for Fair Planning versus City of Sacramento. The California Constitution, for example, grants cities and counties the authority to make and enforce local ordinances and regulations that are not in conflict with general laws. This is part of the California Constitution, Article 11, Section 7. This broad authority is subject to constitutional limitations, including the requirement that zoning regulations must be reasonably necessary and related to the public welfare. The case holding this is Friends of Davis versus City of Davis. Next, what are the constitutional standards for zoning laws? In basic terms, cities can make themselves safe and protect the lifestyle of their town. This is called diversity. Different cities have different characters. Diversity is good. A monolithic, developer-driven building machine is destroying diversity and replacing it with cheaply beat concrete prisons that they call condos and apartments. Playgrounds, ball fields, basketball hoops, forget about it. None of this gets built because the law lets developers do whatever they want. Courts generally uphold zoning regulations if they are not arbitrary or unreasonable and if they have a rational basis related to public health, safety, morals, or general welfare. This means that a city can protect itself. For instance, in the case Lytton International Development Corp. Versus City of Simi Valley, the court held that zoning decisions are presumptively constitutional and will not be set aside unless they are clearly arbitrary and unreasonable. It is completely reasonable for a city to require a for-profit builder to ensure that children have a safe area to run, play, throw a ball, and walk. A city has a right to make sure that schools can handle an influx of new residents without sticking the children in temporary shelters that are cold, cramped, and dark. A city that lacks adequate fire protection can force a mega project to ensure that there is enough water to fight fires and without safe places for the children of the tenants to play cramped TC. The new laws in California blow up these rules so that a city can't even consider whether a 50-unit apartment building next to a 2-lane road with no public transportation might cause traffic jams. Fire evacuation is relevant to people whose lives are in danger, but the builder doesn't have to care. If the land is vacant, they can build. If there is a house that can be torn down, they can build. Safety, quality of life means nothing. This is an unconstitutional taking. Here's why. A state law mandating a city to adopt less restrictive zoning will implicate the takings clause of the Fifth Amendment, which prohibits the government from taking private property for public use without just compensation. This is in the Fifth Amendment to the United States Constitution. The U.S. Supreme Court has recognized that zoning laws can constitute a regulatory taking if they go too far in restricting a property owner's use of their land. This was decided in Penn Central Transportation Co. versus New York City, but the opposite is also true. A regulatory taking may occur when a regulation denies a landowner all economically viable use of their property, which is what happens when you have a house and they plop a 10-unit apartment building next door, which destroys the value of your house. The law also holds that there is a Fifth Amendment violation when the law fails to substantially advance a legitimate state interest and imposes disproportionate burdens on property owners. That case is Nolan versus California Coastal Commission. When you Google that case, remember that Nolan is spelled with 2 L's. In the context of state-mandated zoning changes, a city or property owner could argue that a forced relaxation of zoning restrictions constitutes a taking if it significantly diminishes property values or interferes with distinct investment-backed expectations. For example, in Dolan versus City of Tigard, the Supreme Court held that land use regulations must be roughly proportional to the public interest they seek to advance to avoid constituting a taking. That case is Dolan versus of Tigard. If a state law compels a city to rezone in a way that undermines the city's ability to protect public welfare by allowing incompatible land uses that harm community safety or character, it could be challenged as an unconstitutional taking. Moreover, the takings clause intersects with the police power analysis. While zoning is a valid exercise of police power, a state law that overrides local zoning to impose less restrictive standards might be deemed unreasonable if it lacks a sufficient public purpose or fails to balance the interests of affected property owners. Courts applying the Penn Central framework evaluate takings claims by considering 1. the economic impact of the regulation. 2, its interference with investment-backed expectations. And 3, the character of the government action. Look at Penn Central Transportation Comer versus New York City, a state law that forces a city to rezone in a way that disproportionately harms certain property owners or lacks a clear public benefit could fail this test. The imposition of massive building projects that demand huge infrastructure improvements force cities to fund developers. This is an unconstitutional, unfunded mandate. The website, www.federalism.org, describes unfunded mandates this way. Unfunded mandates are rules and constraints imposed by legislative, executive, or judicial actions of one level of government on other sectors in the economy. Although mandates can be used to refer to regulations imposed on private profit and nonprofit entities, the term was coined to describe regulations imposed by one government on other governments, whether it be federal mandates applied to state and local governments or state mandates applied to their local jurisdictions. Mandates can consist of either affirmative obligations to take action on a policy problem, such as the treatment of municipal sewage, or a constraint or prohibition against certain policy actions, such as the recent federal preemption of state taxation of internet access fees. In conclusion, a state law that forces a city to change its zoning to be less restrictive could be deemed unconstitutional if it conflicts with the city's police power, fails to meet the constitutional standards of reasonableness and rationality, or constitutes a regulatory taking under the Fifth Amendment. Courts will uphold such laws if they are reasonably related to public welfare and not arbitrary or unreasonable. However, local governments retain significant authority to regulate land use within their jurisdictions, subject to constitutional limitations. Any challenge to such a state law would need to demonstrate that it either exceeds the state's police power, lacks a rational basis, or affects a taking without just compensation.